On February 7th, 2002, President Bush issued an order. The order stated, in pertinent part, "I accept the legal conclusion of the Department of Justice and determine that Common Article 3 of Geneva does not apply to either al-Qaeda or Taliban detainees. I determine that the Taliban detainees do not qualify as prisoners of war. Al-Qaeda detainees also do not qualify as prisoners of war. Our values as a nation, values that we share with many nations in the world, call for us to treat detainees humanely, including those who are not legally entitled to such treatment. As a matter of policy, the United States Armed Forces shall continue to treat detainees humanely and to the extent appropriate and consistent with military necessity, in a manner consistent with the principles of Geneva." With these fateful and ill-advised words, President Bush, our Commander-in-Chief, perhaps unwittingly, perhaps not, started the U.S. down a slippery slope, a path that quickly descended, stopping briefly in the dark Machiavellian world of the ends justify the means, before plummeting further into the bleak underworld of barbarism and cruelty, of anything goes, of torture. It was a path that led inexorably to the events that bring us here today, the pointless and sadistic treatment of Mohammed Jawad, a suicidal teenager. President Bush's words were important and deserve special attention. For those of us in the military who have faithfully attended our annual Law of Armed Conflict training, or in my case, have given the training many times, the Geneva Conventions and humane treatment were synonymous. They were one and the same. The Geneva Conventions represented the baseline. They embodied the determination of the world to make war a more humane enterprise, to prevent a descent into wholesale barbarity, as had occurred during the Second World War. But now we were being told that humane meant something else, something less than the Geneva Conventions. And we were being told that we could act inconsistently with the Geneva Conventions when military necessity demanded it. Those of us who were familiar with the Geneva Conventions, whose job it was to know them, were puzzled and deeply troubled by the President's order, and had serious forebodings about the implications of such a decision. We understood that there were no gaps in Geneva. There was no one who fell outside their protection, that Common Article 3 applied to everyone. But the civilian political appointees of this administration intentionally cut the real experts on the law of armed conflict, the uniformed military lawyers, the JAGs, out of the loop, marginalized them for fear that their devotion to the Geneva Conventions might pose an obstacle to their intended course of action. The State Department, led by Colin Powell, tried to raise a red flag, but to no avail. Instead, the administration chose to rely on the infamous torture memos by John Yoo, Robert Delahunty, and Jay Bybee. These secret memos attempted to redefine torture for the purpose of providing legal cover for administration officials who approve the use of patently unlawful tactics. These legal opinions, now disgraced, disavowed, and relegated to the scrap heap of history where they belong, laid the groundwork for the wholesale and systematic abuse of detainees, which ultimately ensnared my client, Mohammed Jawad. I'm sure that all of these people, the President included, thought they were doing what was best. But what sometimes appears to be in the interests of America at first glance, upon further reflection, reveals itself not to be. Interning Japanese Americans during World War II perhaps seemed like a good idea at the time. But in hindsight, we can see that it was a terrible injustice, inconsistent with American ideals, and utterly unconstitutional. It is a shameful episode in our history, a xenophobic overreaction. The conscious, deliberate decision to abandon the Geneva Conventions and the entire fiasco that is Guantanamo will undoubtedly be viewed by historians as an even more disgraceful chapter in our history. The February 7, 2002 order of President Bush invited the rule of law to be circumvented. Even though the president paid lip service to humane treatment by stating that detainees were not legally entitled to be treated humanely, and by his qualification of, to the extent appropriate and consistent with military necessity, the implication was clear. It was only policy to be humane, not a legal requirement. And there would be no legal consequences to those who didn't treat detainees humanely if there was some military justification for it. Of course, during a global war, it is possible to rationalize almost anything under the general rubric of military necessity. After all, if there is even a slight possibility that some military advantage might be gained by some course of action, don't we owe it to our troops to do it? If there is even a minute chance that some sliver of intelligence might be gleaned about an impending terrorist attack, don't we owe it to the American people to do everything in our power to extract it? The obvious answer to most of those working in detainee operations at Guantanamo and elsewhere was yes. Adding to the pervasive atmosphere of lawlessness in the early days of Guantanamo was the administration's assertion that the detainees could be held indefinitely, without charge, without access to counsel, without any recourse to challenge their detention. The administration asserted that the detainees were beyond the reach of any federal court and were not eligible for habeas corpus, a hallowed right guaranteed by the founding fathers of this great country. In effect, the administration created a legal black hole at Guantanamo, a policy universally decried by even our staunchest allies in the war on terror, but steadfastly defended by the administration. If there was any doubt that the president intended unlawful tactics to be used, all doubt was erased when Secretary of Defense Rumsfeld authorized on December 2, 2002, numerous extra-legal special interrogation techniques. These techniques and how they were developed and utilized were the subject of hearings before the Senate Armed Service Committee yesterday and are described in detail in the book Torture Team, which I have attached to this motion. I'm sure Philippe Sands would be honored to have his book included in the record of this commission. Eventually, cooler and wiser heads started to inject some rationality into the treatment of the Guantanamo detainees. Unsung heroes like Alberto Mora, Navy General Counsel, and Admiral Jane Dalton, and the service TJAGs, Major General Rives and Major General Romig, fought vigorously for the restoration of Geneva. But it ultimately took the intervention of the Supreme Court to restore the rule of law to Guantanamo.